For this presentation, we've assembled an esteemed panel of mobile industry thought leaders and experts. Joining us are Ross Buntrock and Michael Hazard of Errant Fox, Rip Gerber of Locaid, and Jared Wrightson and Darren Withers of MobileStorm. We will reserve about 10 minutes or so before the conclusion for a brief Q&A session with our audience. We invite you at any time during today's presentation to type any questions you may have into the little chat box on your screen, and we'll try to get to that before wrapping things up. Again, I want to thank you all for joining us today, and with that, we will start with our first presenters, Ross Buntrock and Michael Hazard of Errant Fox. Mr. Buntrock is a partner at Errant Fox and is nationally recognized for his work in communications, media, and technology law. He regularly counsels a diverse array of players across the mobile landscape and provides strategic policy, compliance, and litigation advice. Michael Hazard is also a partner at Errant Fox. He counsels companies on competitive and regulatory issues associated with existing and emerging technology offerings. He has particular expertise in representing companies before the FCC and FTC. Ross and Michael, thank you for joining us.
Thank you for that great introduction. And again, Ross and I are partners at a law firm called Errant Fox, and we do a lot of work on mobile issues and compliance with various federal and state laws. And I think we can just kind of hop right into our agenda. And what we wanted to talk to you all about today primarily was give an overview of the Telephone Consumer Protection Act, talk about consent under the recent FCC's orders implementing the TCPA, talk about putting the TCPA into practice and various related compliance strategies. So with that, we can just go ahead and move on.
And Michael, you're all set with the presentation, right? We've worked that out.
I'm using just a slide deck that I have. Oh, here it is. Great. It's back up on my screen now, and so I have the agenda slide on my screen. Thank you very much.
I got to say, GoToWebinar has failed about 50% of the time, but I'm glad to see that's up. Let's get going. Thank you.
All right. If we could move on to the next slide. So the industry themes over the last 25 years is we've seen this unprecedented technological change and really a regulatory lag. So we end up having a regulatory scheme that was designed for technology that in many cases is up to 25 years old, and that's kind of the situation we find ourselves with the TCPA. The TCPA was created in the early 1990s to respond to real old-time telemarketing calls during your dinner hour and unsolicited junk facsimiles that would come into your office. And this kind of 25-year-old regulatory scheme is now being applied to things like SMS messages and pre-recorded voice calls and things. So the regulators are really trying to take this really old system and apply it to the current day. If we could move on.
This is Ross. I'm not sure if you can hear me now, but I was able to get back on the bridge here.
Oh, great. I can hear you, Ross. If you want to take over with the overview of the TCPA. Sure.
Sorry about that, everybody. Leave it to a telecom lawyer to have difficulties with telecommunications technology. So as Mike was mentioning, and we'll go back to the originally scheduled program as anticipated. But the overview of the TCPA really is the Telephone Consumer Protection Act is a statute that was enacted in 1991 by Congress. As Mike mentioned, it was really in response to kind of an old-timey now problem of phone calls from telemarketers coming in at the dinner hour and people being very annoyed by that. But what the TCPA does is it sets the ground rules for any marketing done by phone, fax, and has been brought in to include SMS text messages. The other thing that it does is it restricts the use of what are called automatic telephone dialing systems in the statute. It regulates the content of recorded voice calls, pre-recorded, or robocalls. It requires marketers to basically maintain and adhere to a do not call list. And probably the most important fact for purposes of this call and for this webinar is that it provides a private right of action for violations, for alleged violations. So if I'm a consumer and I receive a text message or a phone call that I did not authorize, it gives me the right to sue. And oftentimes these suits are brought not just by a single person who's received these calls, but by classes of people. So class actions for alleged violations of the TCPA have become a growing problem and a material problem that has led, as we'll talk about toward the end of our presentation, to tens of millions of dollars in settlements, in some cases hundreds of millions of dollars in settlements, as in the case of one Georgia case. So it really is material, and thus this presentation today, because we're dealing with a very important change to the way that the agencies view the TCPA rules, or a change to those TCPA rules. As the last bullet notes, both the Federal Trade Commission and the Federal Communications Commission have joint jurisdiction over the federal TCPA, and a number of states have enacted their own versions of the TCPA with slightly different wrinkles, but the overall theme is the same, is that it requires consent. So let's go on to the next slide, and we'll get a little deeper into the concept of what constitutes consent for purposes of the TCPA. Consent basically is a defense. So if you're accused of having made an improper phone call or sent an improper text message, your defense is that, no, I didn't. I had the consent from the consumer to send them these messages. And what the TCPA requires under statute is the prior express consent for residential and cell phone calls that use automatic telephone dialing systems. The problem has been that the words express consent are not defined in the statute, and so there have been different results depending on the body or the court interpreting those words. Up until the order that the FCC adopted in February of 2012, if you provided as a consumer your telephone number, whether it be your landline or your cell phone, to a marketer or a company, that was considered to be prior express consent for purposes of the TCPA. And providing that telephone number it basically created what's called an existing business relationship between the consumer and the marketing company or whoever is sending the messages. And so you could, once they provided that to you, you could basically conduct marketing to wireless and to residential lines, depending on the line at issue. But this is the rub. The new rule that goes into effect on October 16th that the FCC adopted requires prior express written consent to make telemarketing calls to both landline and wireless numbers, at least on a prospective basis. And so where, again, this is really the crux of the entire presentation, whereas you could rely upon them providing you with their phone number before, you now have to have their written consent to continue marketing to them via text or by phone call. And it's unclear whether the previous consent that you may have obtained is going to be considered adequate if those consents are grandfathered, and that's another issue that we'll hit on a little more in depth further on in the presentation. So we can move on to the next slide. This really, the next couple of slides are a kind of a table summarizing what the FCC adopted in their 2012 order that goes into effect on October 16th. And I think I'm not going to go through each of these, but the most important thing to take away from these slides is that telemarketing calls are what has changed. Calls like informational calls, particularly if you're a healthcare in the healthcare space, if you're sending a call if you're making a call or sending a text message for purposes of appointment reminders, the rules don't really change. Those types of informational calls are a separate category. So there's telemarketing calls, there's informational calls, there's emergency calls, and there's a slightly different wrinkle that applies to each of those. But we can click on to the next slide there. Calls made for a commercial purpose, and then you see at the bottom the healthcare call. basically for residential landlines, no prior consent is required, and prior express consent, either written or oral, is required for wireless numbers, which is not a change. So it's confusing, and we can talk through the wrinkles separately offline, but that's a kind of a useful thumbnail. So let's talk about explicitly what do we mean when we say prior express written consent under the new FCC rules. It basically means that there's an agreement that the called person has signed that has authorized you to deliver them a marketing message via SMS or otherwise, via call. And the written agreement, now this is really important, the written agreement has to have a clear and conspicuous disclosure telling the person two things: that by executing the agreement, they are basically consenting to receive messages, and secondly, that they don't have to agree, they don't have to click through and consent in order to purchase goods or services from you. So, we can talk about, again, offline specifics as to what that exactly means, but those are the two takeaways from the plain language of the rule. Now, the other important thing is here, what do we mean when we talk about a signature? A signature means any electronic or digital form of signature that is accepted under federal or state law. In the federal regime, we're talking about the e-Sign Act. Other states have different wrinkles and different interpretations of the e-Sign Act, but bottom line is, if you're compliant with the federal, in most instances, you're compliant with the state's regs and statutes on what constitutes signature. Let's go on to the next slide here. So, what constitutes signed consent? A person can sign the consent. We recommend that you probably, and we'll get this on the next slide, but basically it has to be an affirmative act by the consumer via a website form, an email, a voice recording, and again, you have to clearly identify that the authorized calling party in the agreement, who it is, and if there's any question as to whether or not consent was given, the marketer or the person on whom the marketing has taken place is going to have the burden of proof as to demonstrate that consent was in fact received. Again, written consent was in fact received. And let's go on to the next slide here. This is just some basic opt-in language that talks about, this is model language that we believe would adhere to the best practices. So if you use language like this, it would be adequate for purposes of the new rules in our estimation. The other thing that we should have provided at the top of this was somewhat of a disclaimer, is that we're not providing you legal advice on this webinar, and you should contact us or another attorney if you have questions about your specific practices. The second thing to note on this slide is that for mobile marketers, you are required to integrate the standard carrier disclosures, the message and data rates apply, the unsubscribe instructions, and so forth. So nothing really changes there other than the first bullet on that slide. And with that, I'm going to turn it over to Mike Hazard to talk a little bit more in depth about some practical advice as to compliance.
Thanks, Ross. As noted on the next slide, some of the best practices that you should consider is that if consent is obtained, that you require the consumer to check an unchecked box to indicate agreement. You want to make sure, the bottom line is that the guiding principle is going to be, are you going to be able to demonstrate that the consumer knew that they were signing up to receive promotional marketing kinds of information where you're selling something to them or offering them a discount. And some of these regulations are very, very burdensome, but I can tell you that if you talk to enforcement attorneys at the Federal Communications Commission or at the Federal Trade Commission, they, on a very human level, do not believe that many consumers knowingly and willingly agree to receive SMS marketing messages or marketing telephone calls. Now, they may be wrong about that, but I think it's important for everybody to understand the kind of very basic hostility that the regulators have towards these messages that largely comes from their own experience and from the volume of consumer complaints that they receive. Which is why if you're going to engage in marketing activities, and again, this is selling a good or service or a product, using voice or SMS messages, you really want to make sure you have strong consent, and you also want to make sure that you have a means of maintaining this consent for the 4-year statute of limitations. So if it does come up, if you're ever questioned, you can produce the consumer's assent. The one other thing to note is that the trend in legal circles is that consumers can revoke their consent also. So if consumers can give it to you, consumers can take it away as well. And with that, we can move on to the next slide. The real buzz here in Washington, D.C. is what happens to existing customers. And again, this is in the marketing context. In the informational SMS messages and informational calling, it's a much, the changes are very, very manageable and modest. The kind of strict constructionists say that really the best thing that somebody can do if they're going to do marketing is to make sure going forward that they do in fact go ahead and get prior express written consent from their customers to ensure that they have authority to send them marketing messages. Other people are taking the view that if you just had kind of standard consent prior to October 16th, that should be grandfathered in. I think what everybody should understand is that there is a whole battery of plaintiffs' lawyers out there waiting for these rules to take effect, and they will be filing many, many lawsuits, we expect, alleging that their plaintiffs, their clients, did not give their prior express written consent to receive messages or marketing calls. And then once they make that allegation, it's going to be up to the marketing entity, the brand, to demonstrate that they did receive adequate consent. So it's going to be pretty tough on the brands going forward on the marketing calls unless they have that really kind of crisp, clean, prior express written consent. We expect that some factions of the industry may be going into the FCC to seek a clarification that past consents are kind of grandfathered into the future. But again, given the kind of gut level hostility I've experienced from the regulators, it's not entirely clear to me that those efforts will be successful ultimately, and those kind of asks from the government tend to take a long time. And I guess I would just add that right now the Federal Trade Commission and the Federal Communications Commission are both shut down. So even once they get back up and running, who knows when they'd be able to turn to something like this. And so I guess we can continue on. And again, I just would say that, as I mentioned, that there are just so many different enforcement complaints that the FTC and the FCC receive. It's kind of always number one on the gripes they hear from consumers. As a result of that, the Federal Trade Commission has gotten very aggressive with enforcement actions against companies. And we've seen recently 300 companies face enforcement actions and 200 individuals, and the FCC has issued lots of citations. The big cases that have been out there: Jiffy Lube settled one for $47 million, Papa John's settled one for $16.5 million, Steve Madden $10 million, and Georgia recently upheld a $459 million verdict for unsolicited faxes. Of course, I'm not sure anybody would actually have that much money to pay, but they will, take what you have. So we can keep going. And under these rules, we expect the number of cases to continue. On compliance, a lot of people, especially if you're operating a platform as opposed to being the direct brand, will say, "Gosh, it wasn't me; it was my customer." We've had some success with those kind of arguments, but not a lot of success, especially not with the Federal Trade Commission. The Federal Trade Commission takes the view that if you are in the chain you're part of part of the effort to send the marketing messages. I think that they've been kind of aggressive on that front, but when I sit down across the table with them, what they say to me is, Mike, we get your point. Your client may not have really been involved in this, and they may not have known what's going on, but we think you guys should be doing a better job. And so you can either enter a settlement agreement with us where you agree to do a better job, or we can go litigate this in federal district court, and we can find out if you were right about the law or we're right about the law. People I work with generally do not want to be in federal district court litigation against the Federal Trade Commission. They have a lot of resources and a lot of time. So we always try to maintain good relationships with the governmental agencies to the extent we're able to, and we definitely are all for trying to find a least cost, best solution for the people that we work with. And again,
this is Ross. I just want to add one additional point on that, is that separate and apart from the relationship that you may have with the regulators, their views are being bolstered by some of the legal precedent, including the precedent mentioned there in the third bullet point from the FCC in May of this year, where they basically said, well, we're not going to say that there's third-party liability or that there's vicarious liability for the actions of third-party marketing companies. So if I'm Kmart and I go hire a third-party marketing company to conduct marketing on my behalf, if I turn over to that third-party marketing company, my customer list or certain technologies, or give them access to the things that I own, the FCC has said that we're going to look at that and decide whether, to what extent, third-party liability is appropriate. So it's something to be mindful of and something to be very aware of as you're looking at your contracts and going through negotiations with people who may be conducting marketing on your behalf.
I think it's a good point, Ross. Thank you. But the bottom line is, you want to get ahead of things, especially when it's marketing messages. You want to make sure you're dotting your I's and crossing your T's. And we expect there's been a lot of litigation in this area in recent years. And with this new prior express written consent standard coming online next week, we expect to see many, many more cases. And you just want to make sure that you're as prepared for it as you're able to. And really just keep it run as tight a ship as you can, which can be difficult. We understand that. And I think is that it for us? I think we have a couple more slides maybe.
Ross, Michael, what do you guys feel in terms of what industries you feel that maybe some of these lawyers will go after the most? Any of their favorite ones, if you could share it with us.
The traditional ones, the ones that we see most commonly are in retail. So like a retail couponing kind of system, or any kind of a promotion to get people to re-up a subscription or to buy a service. And I think when we showed the list of the big settlements, it's Papa John's, Jiffy Lube. We've seen cases against organizations like Burger King. We've had gym chains, spray tanning franchises, really in the retail space, and because that's really where the promotion and marketing messages primarily come from. I really haven't been involved in a case involving a truly informational SMS message. So if it's an appointment reminder that maybe your patient has agreed to receive, yes, I agree to get appointment reminders by SMS, or that you can correspond with them or communicate with them over their cell phone. Haven't seen any of those cases. Haven't seen.
And that wouldn't necessarily be considered an advertising or marketing message, right?
No, that would be informational. That would be outside of the kind of telemarketing, the marketing capability. That would be much more of an informational message, which is much more a much safer place to be.
And again, this is Ross. I would also just simply add to that, though, with regard to even some informational messages. If it's, say, you're a cable company reminding a customer to pay a bill, or that some of the other change in their service is happening. For wireless, the prior express consent rules are applicable in some instances, and so I think that you really need to have a granular analysis as to, number one, the type of call it is, but number two, the type of message that's being transmitted, because it does make a difference with regard to the legal analysis in terms of what constitutes or what is adequate prior express consent. But none of these sectors are immune from, whether it's banks, insurance companies, all have been hit by class actions that might have involved in defending in various quarters. So it's no one's immune from the problem.
Great, Ross, thanks.
And really here, we can, I know we've taken up a lot of time here. Again, this is really just that the record keeping want to maintain the consent for the 4 years. And then that way we can be able to respond to any inquiries for the consents that have been maintained. We go to the next slide. And then just a moment on COPPA, the Children Online Privacy Protection Act. The bottom line is you want to stay away from anything where data could be collected from a user younger than 13. Requires parental consent, which again is generally thought to be very difficult to get. I think the most simple way that people end up complying with COPPA is just having a date of birth field on their website, and it's impossible to enter a date of birth if you're under 13. You just can't enter that date of birth, and so you're getting a representation from whoever's logging onto your site that they're 13 or over, which generally will take you right out of COPPA. Again, generally, that there are definitely exceptions. You want to make sure we understand what the offering is. Can we go to the next slide, please? So again, in addition to a screen like that, just the age, the modified rule is really looking to identify items that appear to be, targeted towards children. It can be things like, anything that's like animated or anything that's suggested that's being targeted towards children, and that they're really trying to avoid any kind of tracking of individuals under 13 with either cookies, any kind of geolocation device, or really anything that can track the whereabouts or activity of a child online. So again, I think for most people, unless you're a big brand that's focused on children, the safest thing to do is just try to avoid the entire market of folks under the age of 13. And we continue to the next slide. We've had some interest in people talking about the Helferich patent licensing suit. Helferich is a big, what we call in my business a patent troll. So they go out and they patent all these ideas or items that they never intend to use, and they just kind of create this store of patents, and then they try to sue people for infringing on the intellectual property that they created but have never employed. And this Helferich patent was, for me, one of the most annoying ones, although there are many, many annoying ones. This Helferich organization somehow was able to get the Patent and Trademark Office to give them a patent on placing a hypertext link in an SMS message, which to me is akin of like putting shoelaces into a shoe, but I'm not a patent lawyer. In any event, a number of the large carriers and other people, rather than litigate this with Helferich, just paid them these massive licensing fees for years. But ultimately, the New York Times and some others said, look, we're just not going to take this anymore. And so they stood up to Helferich and litigated it pretty heavily for a couple of years, and were ultimately victorious. And so Helferich is no longer able to enforce that patent under a theory which is known as patent exhaustion, which means just by licensing it out to the carrier community, all the people that you would send these messages through, that gives protection to all the people downstream as well. So we were really pleased with that decision out of Illinois earlier this year, and it really took a lot of uncertainty away from a lot of platforms and other providers that offer SMS messaging and and doing things like including links and messages. So that was, I think, a good result for the industry and for the community.
It really was, Mike. This is Jared from MobileStorm. Pardon me, everybody. I have a bit of a cold, so you have to excuse the raspy voice. I attended a MMA event in Park City not too long ago. It was a CEO CMO summit, and there was a patent attorney that was speaking about this case in particular. This was kind of before the courts ruled in the New York Times favor. But one of the things that he shared with us was a video of President Obama speaking, and in the video he actually called these patent trolls extortionists, or used a strong word or something to that nature, which was kind of the first time ever a president used that word. And it really, I think, is the beginning and signifying major change in patent troll law and what's going to happen here with people that are, not using technology and just sitting on these pieces of paper. And it's pretty exciting. There's a lot of movement in Washington. The Judiciary Committee, the head of the Judiciary Committee is very much involved in changing. They have some reform they've done so far, but Obama said that it wasn't nearly enough, and so they're moving into kind of a second phase. So we're all very excited to see this go away.
Yes, for sure. It was a real relief for many quarters. And that really, I think, concludes our first portion of the webinar, and we really appreciate everybody's time, and hopefully we didn't move too fast or leave anything out. But TCPA is a big issue, and we're happy to talk as long or as little as anybody would like on it. So with that, I'll just turn it back over to the moderator, and thanks everybody very much.
Thank you,
if people have questions
or
otherwise, feel free to email us or call us, and we're happy to talk offline about these issues as well.
Thank you again very much. That was fantastic information, very insightful. For those joining us, that was Ross Buntrock and Michael Hazard of Errant Fox. Still a lot more to cover here with the time we have left, so we will move over to Rip Gerber, founder, CEO, and president of Locaid, the world's largest location company. He is the only CEO to be certified by the International Association of Privacy Professionals and sits on the CTIA's Wireless Internet Caucus Leadership Council. Locaid is the location provider for all real money online gambling operators and apps in the U.S. Mr. Gerber, thank you for joining us.
Thank you very much. So first question is, why is a tech company talking on a compliance webinar? First is we locate lots of devices all over the planet, so geolocation is a big part of our business. As was mentioned, I'm also a privacy professional and do a lot of work with the CTIA. I think mostly the reason is there's over 300 companies where we actually do the privacy and geolocation onboarding and operations for. So that informs a lot of what we do and why we know a lot about compliance. There's three things I want you to get out of the next 5 minutes. I'm going to go pretty quick through these slides, and of course the content and some white papers and summary documents I can provide to anyone who sends me an email. 3 numbers, and those are 4, 3, and 5. 4 is the 4 types of location technologies you need to know about. 3 are the 3 tenets of location privacy. And 5 are the 5 geolocation privacy bills that are currently up and being negotiated. So I'm going to go through those 3 numbers pretty quick. So the first one, if we go to the next slide, is about, if we can hit the next slide, the primer on the 4 location technologies. I have some white papers and some technical documents I'm happy to send to anyone, but the point here is that not all location technologies are created equal in the eyes of the FTC and the FCC. Some, like carrier network location, is governed by the FCC and has certain privacy and compliance regulations attached. Others, like IP addresses, do not fall under the same kind of regulations. So you need to know which location technologies you are utilizing in your business service or in your app. And they are not equal in terms of the accuracy, the speed, the technologies utilized, as well as the compliance regulations that govern them. So that's the number 4. On the next slide, if we can move forward, is the 3 tenets of location privacy. So Mike and Ross did a great job covering a lot around consent, and there are books on consent regulations and happening. The 2 that I want to also mention to you are around notification and control. And what we're talking about here is for the product and marketing people that are on this webinar, what you're trying to do is lower the hurdles of adoption and information collection in your business and with your customers. You want to make it easy to provide those goods and services to your customers, and part of that is obtaining information, geolocation information. On the other side, there's some on the call here that are privacy folks or attorneys, and your job is to protect the company and ultimately to protect your customers and your workers around too much of that information being grabbed and utilized without certain controls in place. Well, that gets into consent, obviously, but also notification. Not only do you have to get someone's permission to geolocate them on their device, you have to remind them once in a while because we as consumers forget. And in most cases, that's every 30 days. You've consented to allow geolocation information to be provided to track my phone in, say, fraud management or an iGaming app or for mobile marketing. You have to remind me usually about every 30 days that that is going on, which is a tickler to say, if you don't want to consent anymore, turn it off. The third one that is not as deep in the bills and CTIA in the future of Privacy Forum and some of the other organizations is around end user control. And with new technologies evolving, where these privacy bills and where these organizations and companies themselves are moving is not only are we making sure we get consent, and not only are we notifying the customers that we have their consent, we want to give them easy-to-use control so they can get in and out of that consent and that decision. It's very similar to the unsubscribe button that you now see on all emails that you get from marketers. So that's 3 tenets of location privacy. And again, if you'd like a summary of those, I'm happy to send those to you as well. I'm not going to go through the 5 privacy geolocation privacy bills in detail, but again, I'm happy to send you a summary of these. But what you should know about, there's lots of different regulations that are coming down the pike. There are also policies that the CTIA, the Future Privacy Forum, and other organizations are putting in place, all focused around consent notification and control. So whether it's the Lofgren or Wyden or Franken here, next slide, Markey, just know that they are out there. They're all evolving. They are all looking at bridging the 4th Amendment to how new technologies and consumers want to behave, and also branching from the law enforcement aspects of consent and information to how we engage with customers going forward. So just know that there's 5 of those, and I'm happy to talk or send you documents on details of each of those, the scope, the covered entities, the implications. Moving to the next slide. Thank you very much. That's okay. That's another Markey bill. Next slide. Just a little bit on gaming. Some folks on the call are interested in gaming. So a number of states here have legalized internet and mobile gaming. And that's an important new twist because there is a lot of regulation. In fact, 10 states now are currently investigating launching internet gaming. 3 have legalized it: Nevada, New Jersey, and Delaware. In fact, yesterday, New Jersey offered its first internet gaming license to a casino. So this is an evolving market, and what's important here, if you're in this industry, is the overlay of geofencing to geolocation, consent, and compliance. If you go to the next slide, it's a bit of an eye chart, but what I'm happy to do is send anyone a detailed summary of the state-by-state regulations for the various applications from poker, lottery, and casinos. But what's important here is to know those 4 technologies I talked about, know those 3 tenets of location privacy. Remember that these geolocation privacy bills are coming down the pike, and look at what your location sources are, or your platform partners, what they're utilizing. Is a location spoofable? Is it accurate? Is it tested? Is it commercial? Do I have the opt-ins correct? Am I notifying the customers of what they're doing? And that's an important piece of legislation that's coming through iGaming, which is unique to this particular industry. On the next slide, I think that finishes up for me. I gave you the couple of numbers. remember that location technologies are not one or the other. Most of these applications in healthcare and gaming and mobile marketing and even M2M are taking multiple kinds of location sources and combining them to hit customer needs as well as regulatory needs. And lastly, on the next slide, I think that might finish my section. No, I think the point here is just we, as Locaid, we do this for lots of different industries, not just gaming and not just marketing. Geolocation is something that is ubiquitous, lots of use cases, as I mentioned, 300 different companies and more using this. The laws are changing, the technology is improving, and if you'd like more information on that, send me an email and I'll forward you the documentation. Thanks very much.
Thank you, Mr. Gerber. That was Rip Gerber, CEO of Locaid. Our final presenters today are Jared Wrightson and Darren Withers of MobileStorm. Jared is the Chief Executive Officer and founder of MobileStorm, a pioneer in the concept of digital marketing and mHealth communications. Darren is Head of Client Development and Casino Services at MobileStorm, and Darren oversees and manages strategic and client services for major clients. Gentlemen, the floor is yours.
Thank you very much, Michael. This is Jared Wrightson, everybody. We pretty much concluded the end of the webinar, so I'm just going to point out a couple highlights about the company and what we do, and then try to get to your questions as quickly as possible because we do have a bunch of really good questions. So just to recap, this webinar was brought to you by MobileMarketingWatch.com. It's part of the MWatch family properties. We also have MGamingWatch.com, which covers anything that has to do with casino and gaming. And we also have MHealthWatch.com, which of course focuses on anything happening in the space of mobile health. Very exciting time right now within mobile health. So between all three sites, we have 5 writers. We publish over 400 articles a month. Our properties have generated more than 1 million unique visitors in the past year. MobileStorm actually owns and operates these sites, although we keep them very independent in terms of what the writers can write about, and very often we even have competitors of MobileStorm that take banner advertisements on the website, and we really try to keep them publishing really good content. We produce some of the most original content and more original content than any dedicated market advertising industry news resource online. So next slide. Real quick overview on MobileStorm. We've been in business 14 years. We have over 1,000 customers. We've sent billions of messages. And at the end of the day, it's all about helping our customers reach their customers across multiple forms of communication. So we have a cloud platform for messaging where we do email messaging to mobile apps, mobile sites, SMS, push notifications, and social media. And it's all about helping our clients communicate with the most amount of relevancy possible. And really, we're working on building the most intelligent communication platform on the planet. So it's a lofty goal, but one that needs to be tackled, because the one thing I think that's pretty consistent theme throughout this entire presentation is how important it is that you have permission. And we are in the age of permission marketing and sending content and information relevant to consumers. And a lot has changed. Years ago, it was all about batching and blasting, and nowadays there's some really good intelligent AI that sits at the ISP level. And if you're sending messages and you have a low engagement, you have low opens, low clicks, those messages start to get deprioritized, if not blocked completely. So it is all about getting permission, and it is all about sending messages that have relevant information and that are timely. And of course, if you are sending messages down to mobile devices, it's even more important that they're timely, because you are going to interrupt somebody's day. Especially when you see 99% of text messages are read in the first 3 minutes. It is going to stop somebody. It's going to interrupt their day, and you're going to get their attention. So you better have something really, really good to say. Next slide. We also work with a bunch of different types of industries, although we focus mostly on retail, healthcare, both payers, providers, and pharmacies, as well as gaming and entertainment. And next slide. We have been recognized over the years for a number of really cool things, and so we're just privileged to have been around this long and to be servicing the industry and trying to provide good content that helps people communicate with their customers and get a chance to, to whatever it is you're trying to do, whether you're keeping people healthy or trying to get people in your door to, to sell them something. So we appreciate your time today. I'm going to jump right into questions, Michael. If you want, we could sort of trade on and off here, but I'm going to go ahead and ask the first question. This is coming from somebody named Rob W. And the question is, if we get telemarketing, landline calls, and we tell people to stop calling us, but they do anyways, what will be our recourse, particularly if we don't have caller ID to get their phone numbers? Would anybody like to take a stab at that on our panel?
Sure. This is Ross. Just make sure I understand the question. If you receive a telemarketing call at home and you don't have access to the phone number, so you don't know where it's coming from, is that the basic question? Is what is
that is the basic question? Yep.
So yep. I guess that's a tough situation, and there really isn't. Unfortunately, there's a lot of kind of spoofing, as you alluded to. I think as Rip alluded to as well. I mean, it's very easy now in this age for marketers to either use a different number than the number that's actually originating the call. VoIP technology allows them to replace the calling information, which is all by the way, illegal. Bottom line is you can make complaints to your state PUCs, you can make a complaint to the FCC, but the problem is, as you point out, it's going to be kind of a John Doe type of complaint because you don't really have anybody to point to other than the name of the company. So you can make a note of the company, find out whether to what extent whether you confirm that your phone number is on the do not call list, but get as much information as you can about the company and lodge the complaint. And in most instances, the regulators force those companies to answer even informal complaints that don't necessarily rise to something that you would want to file a lawsuit about. But that's the best I could advise in that instance. I don't know if Mike has anything more to add on that front. But
the only thing I would add is that's exactly why the organizations like the Federal Trade Commission are really squeezing anybody they can get their hands on. They may not be able to get the specific caller, but they may be able to get one of the providers in the middle, maybe the platform or somebody else, and they will try to bring pressure wherever they can bring pressure to bear.
Great, Michael. Thanks, Ross. The next question is, I think, a pretty good one. Can you explain how this will affect FTEU? That's an acronym for free to end user, or short for free to end user, which is obviously sending text messages over a short code that doesn't end up charging the consumer to receive them. And the question is, may we still send messages to our existing customers who may not have opted in for purposes of reminders, etc.? Free to end user used to let us send messages to our existing clients where they have given us their number but haven't given us permission to text them as of yet. So I guess in a nutshell, under this new these new laws coming out through GCPA here on the 16th, if you're sending messages via free to end user, do we still have to get express written consent, or can we still send messages over free to end user, not charging the consumer? Then the business wouldn't be liable.
This is my free to end users a CTIA / MMA concept. It's not recognized by the Federal Communications Commission or the FTC at all. It's a different paradigm. So the FCC's regulations on marketing calls are going to apply regardless of whether the consumer receives a charge for the message or not.
Yeah, this is Ross, just to elaborate slightly on that. It's all about what kind of call is it, rather than whether they're getting charged or who's actually dialing. I mean, it's all about the content of the call. And if you look at the chart that we provided in the deck, it kind of walks you through the analysis as it regards different categories of calls. But that's really what you want to keep in mind. It's the call's content and the purpose of the call in the first place.
We have a question here from Brian, one of our webinar attendees. How do you anticipate the forthcoming regulatory changes impacting insurance companies? Anyone want to jump in on that?
Yeah, I could take that. Somebody else?
Sure. Well,
Michael, Ross?
I'm happy to. This is Ross. I'm happy to opine briefly. Again, it goes to the content, it goes to the purpose of the message, and so I think that insurance companies, healthcare providers, casinos, gaming operators, I think everyone's going to have a relatively similar type of impact, but the analysis, again, focuses on the content of the call, the purpose of the call. And so I think that it just depends on, it's a case by case, whether it's for purposes of reminding you to pay your premium or reminding you of an appointment or to sell you a new policy. All those things are different types of calls, and the bottom line is that's the touchstone of the analysis.
Yeah, and this is Jared from MobileStorm. We work with a lot of health plans, and obviously, we're constantly focused on helping our clients follow best practices and understand the laws. And so, what we would do is exactly what Ross said. We would take a look at the content. There's a clinical side of messaging that a lot of the health plans use, let's say, SMS for, which would be to keep people healthy or prevention or wellness, maybe flu shot reminder, things of that nature, which aren't necessarily advertising or marketing based, which I don't believe would fall under these latest laws. However, there is also an acquisition side of the health plan business where you are trying to get new customers, and so some of those messages probably would fall under this. There could even be some gray area here as well, where maybe it is a clinical message, but there could be maybe an advertisement on the bottom of that message. And so, I think that it would be probably a case-by-case basis, but it definitely is something that you want to, if you were working with MobileStorm, talk to your account manager about. We've been more than happy. Obviously, Aaron Fox is our law firm when it comes to a lot of these types of things, and we're in communication with them on a consistent basis about these things, and we could even sort of escalate that and just get it under a magnifying glass. We obviously want to make sure that everybody's above board and not going to be dragged into any of these lawsuits from some of these attorneys out there that are kind of going a little haywire with some of the newer laws, which frankly I'm not on board with, and I think that we should have a judge that really starts looking at this and starts to think about mobile in a different way and not throwing it under the TCPA Act. But that's another story. So I have another question here. We're going to try to get this. We've got 4 more minutes left. So let's see here. There's a good one here from, sorry here, guys. I'm just trying to look. This is from Mary E. How would you recommend we handle opt-in situations where enrollment to a program is text to a short code? Darren, you want to take that?
Absolutely. This is Darren Withers with MobileStorm. Opt-in situations for enrollment to a program where they're texting to a short code, you're just going to want to have your standard language on the advertisement as well. You have to tell them message and data rates may apply. You have to tell them how many alerts per month. You really should have a link to your SMS help page on advertisements as well. Anywhere you're saying text a keyword to a short code. It's just kind of covering all of your bases, and this is something we deal with on a daily basis. It's pretty standard, even though we still get those questions from clients. Do I have to put all of it? Yes, you really should. So just think about it. Anywhere you're saying text, keyword to short code 99158, underneath in legible, in a decent font size that people can read, in close proximity to the texting call to action, it should be there. Then they should receive a double opt-in text message, like MobileStorm alerts, 5 alerts per month, message and data rates may apply. Reply yes to continue and join. Reply stop to cancel help for help. That would be a standard double opt-in language. If you're doing location-based services, you do have to mention, to enable your phone's location as well. We've actually changed our system to accommodate longer messages, especially for our casino clients, where they may have to insert problem gaming language like 1-800-GAMBLER. So I've seen these things get into the two text message replies as far as double opt-ins. We've begun to accommodate that. Just to touch a little bit on casino in that respect, when we've been provisioning new short codes for our gaming clients where they do have to be 21 or 18 to be in the casino, many carriers are now requiring in that provisioning process that we have an age verification on the front end, which requires the user to reply yes plus their birth date. And the birth date has to be a valid one in order to make it through that age gate and get into the program itself.
And Roy T says, can you give us specifics on how to get written consent in SMS? And that obviously, I think Darren answered that, but clearly when they reply yes, you are capturing a digital signature, and you would be able to get from any of your service providers that provide your SMS marketing platform a list of people, what the date and time that they opted in, so that you're obviously able to provide that should you get into any hot water.
And the model language that we
I think
provide
maybe we have
is one way to do that, but yeah.
I think maybe we have time for one more question, you guys.
Sure.
Okay. Michael, do you have any questions on your end?
Not on my screen, no.
Okay. Just trying to see if we have maybe one more question here. You know what? It's 11:59. I think we're going to go ahead and call it. If you did have some questions, we'll be able to email those to you, in the next hour or so.
And a quick reminder, I want to mention to everybody joining us on this webinar that this webinar will be available on mobilemarketingwatch.com tomorrow. So if anyone wants to recap what's gone on here today, they will have an opportunity to do so. And we want to thank everybody for their questions and our gratitude to those who took the time to attend today's webinar. Special thanks in particular to our panelists, Ross Buntrock and Michael Hazard of Aaron Fox, Rip Gerber of Locaid, and Jared Wrightson and Darren Withers of Mobile Storm. So for everyone here at Mobile Marketing Watch, thanks for joining us, and we will see you again real soon.